Welcome back. You're watching the Front Row. We'd love to hear your thoughts on the show, especially with regards to alternative dispute resolutions, both at the courts, and we have a representation from the judiciary as well as the government. So we have all the players having this conversation with us tonight here. So we'd love to hear what you have to say. Join us by logging into slido.com. The event code is the Front Row. You can as well join us on Twitter at K10NewsKE. You can as well tweet me at Akisa Wandera. The hashtag to use is the Front Row. You can as well text us on 22155. And of course, don't forget to indicate your name and where you're from, even as you contribute to the conversation at this hour. Before we went on a break, the PS spoke expansively about the stipend meant to cushion those that have lost their jobs. And I asked a quick question that I would really like you to only respond to in a very short time before we get to the other panelists. How does one enroll to get this stipend? What's the criteria?
Thank you, Akisa. Yeah. What happens is that this committee that sits at the Ministry of Labour is interagency. We have other agencies represented. We also even have the Kenya Federation of Juakali Association representative in the committee. And what it just does is to recognize those that have really lost jobs. And what happens is that through the associations, we can be able to get their names, we can be able to get their numbers, we can be able to get their location. And then once we have that list, we now verify. It goes through the verification mechanism in the ministry and our partners like Safaricom. Once these have been verified, then we give them a weekly stipend of 1,000 shillings. Right. So the verification aspect is interagency, and we have representatives of those that, the associations of those that are going to benefit.
Right. And when we talk about the court-annexed mediation, back to you, Ms. Anna Madi, there's a question on then, how do you decide which case goes to mediation? Take us through this process.
Of the civil cases are actually amenable to mediation. You do not expect to mediate, for example, a case of violence. So any case that is of a civil nature, whether it is a labor relations matter, unlawful termination of employment, a debt collection, all these cases can actually be mediated upon. And in many situations, it is the judge who will suggest to the parties to try it out. In some situations, the parties themselves can actually say, we want to try and negotiation, and they'll be free to do that. So basically, any kind of case can be mediated upon. And we have a deputy registrar that is in charge of that. They will look at the matters. They will allow, help the parties to pick the mediator that they want. We have a register that has been created by the Mediation Accreditation Committee. So the parties can either choose anybody that they want to be their mediator, or the court can also suggest, so that if both parties are willing, then they'll be able to have that mediator take them through the process. Of course, the process is such that the mediator really just facilitates the discussion between the two parties. The mediator cannot make a decision. It is the parties that generate options and come up with their own solutions. So it's a very empowering process compared to a process where the judge is actually delivering a judgment and you don't have a say. The mediation process empowers you to have a say in the outcome of that dispute. Again, the mediator has a time limit within which to deliver an outcome. The maximum period that is given is 60 days, which can be extended by another week or so, depending on if the parties require more time. So we see that it's a process that really enhances access to justice for all. It helps us quite a bit in reducing backlog because of the time limit within which the dispute has to be resolved. It's also very, very cost effective because there's a lot of costs that go with several attendances, that is typical of a normal hearing process. So it saves time, it saves money, it reduces even the stress that is associated with the litigation process. It creates an environment of accommodation and friendliness so that by the end of that mediation process, the parties' relationship is more likely to be maintained as opposed to a situation where there's a judgment against me and one person has won, the other one has lost. It kind of gives us a win-win situation. So it is something that we really encourage.
Right. And when we talk about unions, and you've largely talked about the MOU and how it's working for workers, the PS mentioned that there are 2.9 million people employed in the informal sector. So then most of them have lost their jobs. When talking about massive job losses, most of them come from the informal sector that is largely not unionized. How are we engaging this group of people even without them being in unions, Mr. Nadomi? And on top of that, then there's those in the formal sector who are not unionized. How are we also engaging this group of people, especially during this period?
Thank you very much, Kisa. Maybe kindly allow me to just give some comment on the guideline. It is very true that in the words of Jacqueline, this was agreed mutually by the tripartite partners. But we find some action that taken place that is not in good faith, which I must point out, because if you have an agreement in this case now an MOU, that is mutually agreed, but here is a case whereby the Ministry of Labor went further and gazetted this document. What does that tell you, even for lawyers? When you gazette a document, doesn't that imply that it is now anchored in law? This we mutually agreed, and that is why I will still insist that some employers now are taking advantage. The fact that this particular MOU, which was mutually agreed, has been gazetted. Some of the employers now are saying the fact that it's been gazetted, they have to abide by it, and they have to act, and really, if it is a matter of suspending the CBS, some are already doing it. If it's a matter of not negotiating, that is already happening. But let me just put a right that we appreciate a lot the effort made by FKA, led by the CEO Jacqueline Mugo, in really trying to sensitize employers to understand really trade union is all about dialogue. Trade union, and that is why we have that challenge. Even as we speak now, the unionization level in this country is a bit low. Why? Because we are already in court, and I'm happy that we came back. I'm a member of the Labor Board, where the CEO of FK is also a member of the Labor Board, and it's a matter now that is before us, because the current constitution, Article 41, allows every Kenyan, every worker has a right to join a union. Every worker has a right to collective bargaining agreement. So, but now what happens? When the unions engage employers that we want to enter into a recognition agreement, it becomes difficult. The employees are intimidated. The employees are sad for accepting to join the union. And why? Their point of reference is the labor statutes that were passed in the year 2007. But at least we are engaging now. We want to come up with a middle ground. And that is the very reason why, to answer your question, in the informal sector, I can tell you, and a whooping 85% of employees in Kenya are in the informal sector. When it comes to unionization, is that working? That is, we're having an Herculean task there. But I'm happy that so far, COTU is engaging these particular employees through the association. But nothing stops us, and currently as it is, nothing stops those employees. And I think, let me inform any Kenyan, any worker who is aggrieved and is not represented by the union, nothing stops you from going to COTU offices, nothing stops you to go to any trade union and seek assistance. We will listen to you, we will communicate to labor, and if you don't agree at the conciliation level, we will escalate that matter to the labor courts. So this is where we are, but where we have CBAs, and I think I must put this clearly, where we have collective bargaining agreements with employers, we've been able to engage. But the issue, and I will insist, whether somebody likes it or not, down there, the situation is different. When it comes to employers, we agreed, yes, on these guidelines, but when it comes to implementation, it is a sorry state where quite a number of employers, and maybe a big chunk of these employers, are also not affiliated, are not members of FKE. They have sent employees home. We have numbers, we have statistics here at Kotu where we are talking of almost 1.5 million plus employees have lost jobs. So this is what we are battling now. What do we do in terms of really bringing to the bracket the employees who are in the informal sector? And we still have those, as you rightly put, those who are not in the informal sector, in the informal employment, but they cannot join the union. So these are the hurdles that we are facing, right. But at least there is a light at the end of the tunnel, because we are now engaging at the labor board to see how really these particular employees are not represented, also really get their rightful representation.
Right. Yeah. Ms. Mugo, I believe you'd have I'll give you a right to respond from some of the things that have been mentioned there by Mr. Nandome, and especially on how the employer is treating this MOU so far.
Thank you, Akisa. If ever there was a time I was proud of the work that the Federation of Kenya Employers and the social partners have done, it's been during this COVID-19 pandemic crisis. It's been a terrible crisis for us, and we were able to show leadership and come up with a memorandum of understanding that is founded on the bedrock of labor relations: social dialogue, accommodation, consultations, negotiations, and give and take. It means that if a problem arises, then those same parties come together to discuss it. The Federation of Kenya Employers stands for fair labor practice, and I can say every good employer in this country is a member of the Federation. The fact that it's been gazetted, to me, does not take away the spirit of the Memorandum of Understanding. It is, if you look at the wording of the Memorandum of Understanding or the framework agreement that we signed, it gives the power to the parties and mandates them, behooves them to sit, dialogue, and agree. It's very difficult for one party to act unilaterally, and that's been I think that's been the one thing that has brought in some element of sanity through this process. Where problems arise, and it is true, there could be some employers who are not members of the Federation, may not even have heard of the Memorandum of Understanding, who should join the membership of the Federation of Kenya Employers to be able to learn about this MOU going forward. Because I believe the topic we are discussing tonight of alternative dispute resolution, ADR, will be a feature of our labor relations going forward. Right. It has been, because what we do is conciliate between parties, and what Kotu is painting about a scenario where employers are acting unilaterally is a scenario I'm not aware of, so we need to sit down and discuss those issues. But going forward, I think as leaders, we need to keep showing this leadership role and the spirit that we adopted so early when the pandemic came upon us. That's the only way we'll be able to recover, because the partial opening of the economy is just the beginning. We have a long way to go. Okay. And that is what will ensure that we're able to protect jobs. Okay.
Mr. P.S., there's a lot of questions here, and especially around job losses. Someone here asks that if they have been jobless, but when things resume, will they be the ones to be employed, or are we going to employ new people? Another one asks, are private school and BOM teachers going to be given stipends by the government? Another one asks, I'm a teacher and my salary has stopped since COVID-19 started by TSC. Where can I go? I have been on unpaid leave since March, and I wonder who are getting the stipends. That has been addressed. As you give us your closing remarks, I'd also like you to respond, Engineer Toom, to the issue of compliance with this MOU that has already been gazetted. How's the ministry going about this, even as you give us your closing remarks?
Thank you very much, Akisa. And let me take this opportunity to thank the panelists, particularly the social partners who have really worked with us during this time the government has been battling the pandemic. And let me just go back a little bit just to explain how our institutions are set up within the Ministry of Labor and Social Protection. We have the National Labor Board that we alluded to. And the National Labor Board consists of our tripartite partners, that is the CEO, FKE, and the SG of KOTU. Right. And basically what the National Labor Board is an advisory unit that advises the ministry on all social issues that are affecting the employment sector in this country. So again, even the decisions that we are making as a ministry, apart from the policies that we have, we usually ensure that all of us are on the same page. And that is why, Akisa, we came up with this MOU that is now currently being used in the country. And like Madam Mugo said, you know, gazettement is part and parcel of popularizing, so that at the end of the day, when workers and employers are discussing their issues, they are able to have a document that they can make reference to. And when we muted that document, Akisa, we were looking at social dialogue, right. Nothing outside the same. Okay. So by the time they make agreements, they will have, of course, had some sort of discussions. All right. You're closing. And then we have the ADR. And then we have the ADR mechanism, which, of course, is populated by conciliators. And that, again, like Nadome said, it is worked very well in this country. And then we have the Department of Labor. And I want to focus a little bit on the Department of Labor because it is the one where, it is in that department where we've domiciled the multi-agency committee that looks at the job losses that we are currently experiencing. And whenever, and I want to take those questions together, the job losses and how do we apply.
So I'd urge you to really rush through them. So,
yes, I'll rush through them just wholesale, and I will be able to say that those that think they have lost jobs and they have been employed in the informal sector and they are currently suffering, they can be able to contact the ministry through that multi-agency committee, who will then vet and subject the same applicants through some mechanism that they will be able to fork out those that warrant to be assisted. And let me tell you also that we have the labor officers in the counties who can be approached for more information on how you can be able to apply for the same.
Okay. All right, thank you very much. There are two questions for you here, Mr. Madi, so you'll answer them as you give us your closing remarks. One says, I'm John from Nairobi. Is it legal for an employer to fire employees as redundancy without a send of money? Mind you, these fired employees have a family to feed. And then there's another question. If I win a certain case against my employer, can I recover costs from the opponent without intimidation? And what is the process? This is Nixon Dugire from Kindaruma. I'll have you respond to those two questions, even as you give us your closing remarks.
Redundancy is a legal process. The only thing the court will look at was whether the process was properly followed. If yes, then it is legal. If you win a case, yes, you're entitled to costs without intimidation. As I close, I just want to say this, that out of the 4,250 cases we have so far referred to mediation, we've seen that we've been able to release 8.1 billion shillings to the economy at a disposition rate of 69 days per case, and with a 50 and a bit percentage success. So that means that's the way to go, even in terms of making Kenya better, in terms of making Kenya, more attractive as a business destination. So I just want to encourage all of us to embrace ADR and quota next mediation. Thanks, Akisa.
All right. Let's get the closing remarks from Mr. Nadome. From the union side, what do you think then would be the place of ADR in the future and even post-COVID when we're talking about a recovery strategy?
Akisa, to us workers, ADR is the way to go. ADR is the way to go. As I told you, the people who bear the brunt when we have this backlog of cases, it is us. It is expensive, it is costly, it's time-consuming to move to go to court, and that is the very reason why I alluded to the fact that we've made quite a lot of progress, and that is the very reason why we've not had so many strikes from amongst the public sector unions for the last 1.5 years. Maybe as I finish, Akisa, there is something that I must mention post-COVID, if you allow me. Code 2, which is the workers, most representative workers representative body in this country, we have had an elephant in the room when it comes to matters of employment. And this is with utmost respect to employers. We intend to, once the Parliament appoints the chairman of the Labour Committee, we are almost at the tail end of doing a paper to that particular committee where we will want a change in legislation and in terms of the nature of employment. And this is particularly the issue of outsourcing. Right. As we talk, Akisa, this has been a big issue for us, and what we will want is that once we engage the Labour Committee in Parliament, we will want the legislation to be changed so that all outsourced employees who are working for outsourced firms in any institution, their terms and conditions of service should match the same as that of those particular employees who are working for the parent company. I think this will really address the concerns where you will find even banks, like currently banks, you will have security courier guys doing, Askari is doing clerical job. And this is a way of circumventing or really people, workers benefiting what is rightful there. So that is the direction I want to take. But otherwise, thank you very much, Akisa.
Thank you very much for all joining us here for the front row. And we've come to the tail end of the program. We will be continuing with this conversation. A lot needs to be canvassed that we can't quite finish in this sitting. Our guest tonight, Engineer Peter Toom, the PS State Department of Labor, Ann Amadi, Chief Registrar, the Judiciary, Jacqueline Mugo, Executive Director, Federation of Kenyan Employers, as well as Ernest Nadome, Assistant Secretary General, Code 2 Kenya. Thank you for joining us for the program, and for you, the viewer, for engaging with us in this very important conversation. They say ADR is the way to go. We'll see how effective it's going to be in the future. I am Akisa Wandera. Thank you for watching.